emphasize, I think the issues at point here are whether a relationship existed, whether that relationship was romantic or non-romantic in nature, when it formed, and whether it continues. And that's only relevant because it's in combination with the question of the existence and extent of any personal benefit conveyed as a result of the relationship. With that being said, I don't think that means that everything that has been raised in the defendant's motions, and Mr. Roman's or in the ones adopted by co-counsel, demand an evidentiary hearing. The testimony that would be produced at this hearing is not a deposition. It is still subject to the rules of evidence. And so I think the facts that are going to be developed on the record have to have some relevance and some materiality. Now, contradictions or how things play out could impact that, could change what is relevant. But at the outset, there are a few things that I don't think are. So to that end, I don't think the particulars of Mr. Wade's experience are relevant. I don't think those are material for an evidentiary hearing. His alleged lack of experience handling RICO cases or any inferences regarding the intent from that can be addressed at argument. But in my mind, as long as a lawyer has a heartbeat and a bar card, that lawyer's appointment standing alone is a matter within the district attorney's discretion. Similarly, I haven't found a reason to find that the regulations or the alleged violations of Fulton County Code are relevant in and of themselves. I think the violations of these rules can be argued as a matter of law if counsel wish to do that. But I've yet to see case law or anything indicating that these violations, if they did occur, are relevant to disqualification or a pending criminal case. And then finally, the motions have also evolved to include forensic misconduct on behalf of the district attorney. And again, I don't see how these are a necessary topic for an evidentiary hearing unless it's made an issue in some way. The public statements, in my mind, speak for themselves, and the application of the law to those statements can be argued, and I don't think any further testimony qualifying them is going to affect the analysis. So with that being said, I'll turn it over, Ms. Merchant, to you just at the outset. If you have anything you want to preserve for the record or to reply on, and then from there we can take up the motions one by one.
No, Judge, we appreciate that narrowing issues, and we did plan on being narrow in the evidentiary issues that we were going to be litigating on Friday. As far as those topics, like you said, I think all of those things are already in the record, so we're just planning on arguing those as far as the law. But the evidence we'll get into a little bit deeper with the motions to quash.
All right.
Thank you, Judge.
Okay, so let's turn. I didn't really have an idea of the particular order, unless anyone's jumping up and down and says they have another conflict they need to get to. Why don't we start in the order that I received them? So I think the first one we got would have been from Ms. Cross on behalf of the district attorney. And Ms. Cross, the floor is yours.
Thank you, Judge McAfee, and I appreciate the narrowing of the issues. I think that the state's motions to quash all relate to the areas that you consider to be available and open, so would be potentially still be the subject of any evidentiary hearing held this week. I think from the state's perspective, and as the court is aware, Ms. Merchant has subpoenaed a total of 9 employees of the district attorney's office, including the district attorney herself. Those range from the opposing counsel on the prosecution team prosecuting Mr. Defendant Roman, current and former members of that team. It includes individuals who have no direct relation with the prosecution, but also no relevant information, including the district attorney's personal executive assistant, members of her security detail, and other individuals who are employed by the office and quite outside the area that the court has determined to be of relevance in a future evidentiary hearing. The state's position is, and I think the evidence is clear, that these witnesses who Ms. Merchant or no opposing counsel has ever spoken to cannot be in good faith represented to the court as having information that would be relevant to any of the individual issues that the court has identified to being of interest. These witnesses, again, have never been spoken to, and nor Ms. Merchant nor anyone else can represent what they would say I will represent, however, what they would say. They would not in any way support the wild speculation that was included in this motion. It would not support, as was raised in the reply brief that was filed this morning. Ms. Merchant represented that these witnesses subpoenaed, I think 2 weeks ago now, prior to the filing of Mr. Wade's affidavit, that any of these witnesses would refute the allegations or the representations that were made in the Wade affidavit. The allegations and the speculation from Mr. Roman's initial motion has been, I think, is clear to the court now. There have been several representations that were made that were not true, were not in good faith, could not be supported. These witnesses that have been subpoenaed now for a hearing this afternoon have nothing at all to add to the allegations that were made, nothing in support, nothing that would undermine the affirmations that were made in the Wade affidavit. The affirmations and the facts sworn by an officer of the court that were made are categorically true. They're 100% true. And there's no witness, certainly none of the 9 that were subpoenaed, that are representative of the district attorney's office that will say otherwise. We've pointed out to the court all of the law that disfavors a defendant or any litigant subpoenaing opposing counsel or members of the opposing counsel's litigation team. A criminal defendant does not have the right to make claims without admissible evidence and then subpoena the other side in an effort to conjure up some evidence to support them. That's not serious. That's an abuse of the subpoena power. It's the defendant's burden, now that the motion to quash has been filed, to establish the relevancy. And the state believes that there's just no way to make that claim in good faith, given the record that's before the court now. Let me phrase it this way. This is a serious case. These are serious charges. Your Honor has been running a serious courtroom. And in response to the accusations that were made, the state presented the court with law that establishes that even if all of the allegations were true, and they're not, that is not a basis to either dismiss the indictment or disqualify the district attorney's office. The state has brought you the law. The state has brought you facts in the form of a sworn affidavit from the officer of the court, identifying the timeline of the relationship, the facts as it relates to any financial involvement related to the allegations that were made. There is no personal interest on behalf of the district attorney or her office in the prosecution of this defendant. And there is no financial interest in the prosecution or conviction of this defendant by the district attorney's office. The travel that was taken, as represented in the affidavit, was roughly equally divided between the two of them in terms of responsibility. And there's no evidence that can be brought that would dispute that. These are serious charges. The state has responded to them seriously. And I think the court's action here will be informed by the other motions to quash that you'll hear this afternoon. My understanding is that of all of the witnesses subpoenaed, there will be no individual who has relevant information that would dispute the affirmations in the Wade indictment. The defense is not bringing you facts. The defense is not bringing you law. The defense is bringing you gossip. And the state cannot, and the court should not, condone that practice. I understand the court's representation, or I understand the court's position that an evidentiary hearing is required. If that is required, none of the witnesses identified here in the state's motion are properly subject to subpoena. And so that's addressing the employees of the district attorney's office and the district attorney. The state also filed a motion to quash the subpoena to Mr. Bradley, I believe is his name. Mr. Bradley is someone who was a former business partner of, thank you, the former business partner of Mr. Wade. He was also his attorney related to divorce and domestic matters, and that relationship began in 2015. 2015 far predates any allegation relevant to the motions, that attorney-client representation continued through and including, I believe, 2022. There has been no waiver of privilege of that. And I believe that the evidence or the record before the court would demonstrate that defense counsel knows that this relationship, attorney-client relationship exists, that she knows there will be a privilege invoked, and that it just is designed to obtain more public relations, more spectacle, and that the subpoena to Mr. Bradley should likewise be quashed. I believe Mr. Evans, if he's here now,